Thanks for joining us today for Jennifer Shaston Associates in our Webinar Wednesday program live from Washington, D.C. We are uncovering each part of the DFARS, or Defense Federal Acquisition Regulation Supplement, every Wednesday at 12 p.m. Eastern. As you know, the DFARS are the rule books for contracting with the Defense Department. We've been moving sequentially, so we started with the DFARS Part 201 in January, and we will be finishing with Part 253 in December. Our webinars are every Wednesday and are provided complimentary. They're recorded and can be downloaded from our website and YouTube channel, which now holds over 450 of our government contracting webinars. In the interest of time, we do not take questions, so if you have questions for our speaker, we will have his contact information on the last slide of the presentation today. A special thanks to our educational sponsor, the National Veteran Small Business Coalition, for making these webinars possible. The NVSBC is the largest nonprofit trade association for veterans. Please visit their website for more information. Virginia PTAC at GMU offers free one-to-one counseling to firms in Virginia on federal, state, and local procurement topics. Online resources and group trainings are free with no restriction on business location. If you are interested in learning more, please use the links provided to explore what PTAC can offer. Set Aside Alert provides up-to-date news, information, and opportunities for small business federal contractors. Their daily opportunity alerts assure you won't miss important sources sought and solicitation announcements, providing details so you can jump on the hot ones. Every 2 weeks, they deliver concise breaking news, events, regulations, and teaming opportunities. Please join the Reston Chamber of Commerce Government Contractors Council for regular meetings. Please contact Alicia Field with the email shown on the screen if you have any questions. And federal contracting is a relationship game. Now get in front of your federal humans sooner with the exclusive Players and Layers method from Judy Brett and Summit Insight. Connect with her on LinkedIn and find out more or visit growfedbiz.com today. And if you are interested in selling to the federal government, you may need a contract vehicle. The most popular one is the GSA schedule. Learn more about the requirements, the proposal process, and how this contract vehicle may or may not be the right tool for you. Jennifer Schaus is teaching a series of several classes, as you can see here. All classes are listed on our website under the events section with the registration link. And now a little bit about us. We work with U.S. federal government contractors, including product, service, and software firms. Our services range from market analysis reports to contract vehicles and compliance. More information is on our website. And we also have opportunities for your organization to advertise in our newsletter. We now reach over 23,000 subscribers, and this includes both contractors and government. Contact us for pricing information with the email shown on your screen. And I also wanted to inform you of a new series in 2021. We have launched a monthly series called the GovCon Live Q&A Cafe. This is a live webinar series held each month. These will take place on the second Friday of each month in 2021 at 12 p.m. Eastern. We've assembled a group of 4 panelists who are subject matter experts on a specific federal government contracting topic. The panelists will make a short presentation about the topics listed here on your screen and then take your live questions about that topic. So, for example, our panelists covered subcontracting last month, and this month, on June 11th, our panelists will be covering sales and capture. Our panelists include attorneys, consultants, and other industry professionals. You can sign up on our website under the Q&A Cafe tab. Sponsorships are available. Please email hello@jennifershops.com for a media kit with pricing details. Also, please note you can use code DFARS for a $15 discount on each webinar. And now to introduce our speaker for today, Daniel Ramesh. Welcome, Daniel. We're glad to have you here with us today, and I'll turn the floor over to you.
Thanks so much. Thanks to Jennifer Schaus and Associates and to our sponsors. My name is Dan Ramesh. I'm with the law firm Smith Packard McWhorter. My presentation today is just for informational purposes and is not legal advice. So with that caveat out of the way, I'm going to talk to you today about DFARS Part 224. Which addresses DoD's Privacy Act and FOIA programs. If we can move forward to the agenda, there we go. We will look at the regulation itself, DFARS Part 224. For background, we'll look at the Privacy Act, the Freedom of Information Act, FAR Part 24, which is the section of the FAR that corresponds to this DFARS part. And then we'll take a closer look at DoD's privacy program and FOIA program. Next slide, please. So this is DFARS Part 224. That's all of it. You may be thinking, well, this is going to be a short webinar, but not so fast. So DFARS subpart 224.1 refers to DoD rules and regulations in DoDD 5400.11 and DoD 5400.11R. And then subpart 224.2 refers to DoD implementation of the Freedom of Information Act in DoD 5400.7 and then 5400.7R. So these are references to DoD issuances, which are documents that establish DoD policies and procedures that are binding on DoD components to which they apply. And DoD's directives division oversees issuances. And of course, it will come as no surprise that there are issuances that govern the issuance of issuances. So lots of rules, but there are really, I guess for a little bit of background on issuances, there are really three types: directives, which are policy documents signed by the secretary or deputy secretary. They're supposed to be short, 10 pages or fewer, kind of high level. Instructions are a little bit more detailed, up to 50 pages, signed by the cognizant Office of the Secretary of Defense or component head. And then there are manuals, which have even more details. Of course, the issuance policy isn't always followed exactly, and there are issues here. So DoD 5400.11 is an instruction. DoD 5400.11R refers to itself as a regulation, although it's really an internal policy guidance document for DoD personnel and applicable contractors. There is also a there is actually a DoD regulation governing DoD's Privacy Act program. That's at 32 CFR section 310. DoD 5400.7 is a directive, and then there's also a manual at 5400.7, which supersedes this 5400.7R that's referenced in the DFARS. So one of the themes you'll notice here is that the DFARS isn't fully up to date with other events that have occurred. It kind of takes time for those rules to be promulgated. So if we can go to the next slide. First, it would be helpful to have a little bit of background on the Privacy Act. The Privacy Act imposes rules for how federal executive agencies handle personal information. The term most people are familiar with is personally identifiable information, or PII. The Privacy Act is all about PII. It governs the collection, use, and disclosure of PII that agencies store in what they call systems of records. And the goal of the statute is to balance the government's needs to gather and use information against the individual's interest in maintaining control over information that about them that the government collects and maintains. So the statute generally restricts disclosure of PII without an individual's consent, subject to certain exceptions. The law also grants rights relating to data, so access rights, the right to amend information that is incorrect or irrelevant, untimely, or incomplete. There are also civil remedies that the statute provides for. So if the government violates the statute and allows unauthorized access to your information, then the statute provides a right for individuals to sue. And there's a minimum $1,000 civil penalty per unauthorized disclosure. The statute also imposes rules and requirements on agencies in terms of collecting information. So it requires information about individuals to be collected directly from individuals when it might affect their rights, benefits, or privileges under federal programs. Again, to kind of preserve the accuracy and have some accountability there. It also gives agencies a responsibility to ensure that records are accurate. And it also imposes rules limiting collection of some kinds of information for policy reasons. So, for example, data about exercising First Amendment rights. Next slide. So, why is the Privacy Act important to contractors and government employees who are involved in procurement? If there are contracts where the agency operates a system of records on behalf of the agency, then the rules that apply to the government in terms of implementing the Privacy Act also apply to contractors and contractor employees. And there are criminal penalties for government employees that mishandle information in violation of the Privacy Act. And those criminal penalties also apply to contractor employees where the Privacy Act applies to the contractor. These requirements are triggered by contract for an operation of a system of records. The civil penalties don't apply, but again, the criminal penalties apply, which can be a misdemeanor and a fine of up to $5,000 for a violation. Next slide. So it makes sense to read DFARS 224 in conjunction with FAR Part 24. Of course, that's the nature of agency supplements. The FAR Part subpart 1.302 limitations limits agency acquisition regulations to what's necessary to implement FAR policies and procedures, and then additional policies, procedures, and solicitation provisions or contract clauses that are needed for specific needs of the agency. And so generally, agency supplements, including the DFARS, are not supposed to conflict or be inconsistent with the FAR unless there's a deviation that's authorized per FAR subpart 1.4. The DFARS is really the most notable agency supplement because, of course, something north of 60% of federal procurement dollars are spent by DoD and DoD procurements. So DFARS covers a significant proportion of all federal procurement. And of course, DoD prior to April Fool's Day in 1994 was governed by a separate regulation, which was then called the Defense Acquisition Regulation, previously referred to as the ASPR. So the DFARS has a special place, but that's a little bit of an aside. Bottom line, it makes sense whenever you're looking at agency supplements to read them as a complement and extension of the FAR itself, specific to the agency. So if we look at FAR Part 24, which corresponds to DFARS 224, 24.1 addresses protection of individual privacy and includes some definitions that are pertinent to the Privacy Act, so operations of systems of records, and talks about the kinds of activities that might be in a contract relating to systems of records with PII. It has the definition of PII and references OMB Circular A130, which has more information on protecting PII. And it also defines records and systems of records, and the record definition includes, some of the examples of the kinds of records that an agency might maintain: educational records, financial transactions, medical history, criminal and employment history. So stuff that is important to protect. Now, I think we're ready to go to the next slide here. So 24.1, protection of individual privacy. The FAR emphasizes contracts involving PII, and the contracting officer here has the responsibility for determining that the Privacy Act applies to a specific contract. And if the Privacy Act does in fact apply to the contractor and contractor employees, the FAR sets forth the ways that the agency is supposed to tell the contractor. So there's supposed to be something in the statement of work that identifies the system of records and the work that's going to be performed relating to the system of records. They're also supposed to include the FAR clauses 224.1, 224.1, and 52.224.2. And the agency is also supposed to provide their rules and regulations implementing the Privacy Act to the contractor, because again, the contractor is supposed to follow those rules and regulations, operating the system of records on behalf of the agency. Then subpart 24.3, which I won't go into, privacy training, deals with training the contractors need to provide both on an initial basis and then annual training to employees that'll handle PII under a contract. Go to the next slide. So the other statute that is kind of an important background for this section of the DFARS is the Freedom of Information Act. So the Freedom of Information Act addresses the right of access to government information for interests of transparency and accountability. It was enacted in 1966, and it requires government agencies to disclose a broad range of government information to the public. There are really three mechanisms under the Act for doing that. The most well-known is the authority under FOIA to request information, FOIA requests. But there are also two other mechanisms for disclosing government information under FOIA. FOIA directs agencies to publish rules along with other important government materials in the Federal Register. And it also requires agencies to electronically disclose information, including final adjudicative opinions and frequently requested records. And so an adjudicative opinion would be, GAO decisions on bid protests, or Armed Services Board or Civilian Board decisions on claims, for example. The frequently requested records are, come up in the DoD context with FOIA libraries, and we'll talk about that a little bit later. So, but I guess going back to the part of FOIA that is most well known, individuals may request and obtain without explanation or justification existing identifiable and unpublished agency records on any topic. That's kind of the key requirement that gets the most attention, the FOIA request. We can go to the next slide, please. So, although the purpose of FOIA is to provide for governmental accountability and transparency, the Act also recognizes certain private and government interests in not disclosing certain categories of information. And some of these categories are obvious information that's classified, or information relating to law enforcement. But the two of the exemptions that I would highlight here briefly, Exemption 4 is very well known and is well known to contractors in particular, covering trade secrets and other proprietary company information. And of course, contractors have to provide a lot of that in the context of submitting proposals and contract performance. Exemption 3 is also very important to contractors. That is information prohibited from disclosure by another federal law, and both Title 10 and Title 41 include prohibitions on release of contractor proposals, with an exception if a proposal is set forth or incorporated by reference in a contract. So that's another FOIA exemption that often comes up for contractors if there are FOIA requests for contractor proprietary information. In addition to the 9 exemptions listed here, there are also 3 exclusions that relate to certain law enforcement records, and those exclusions basically treat those records as if they don't fall within FOIA. So just another little nugget there. If we can go to the next slide, please. So again, to look at the FAR, subpart 24.2 addresses FOIA, and again, it notes the requirement for information to be available to the public by publication of the Federal Register. That's one of the other mechanisms I had mentioned. And then it provides for opportunity to read and copy documents, or providing a copy of reasonably described records, FOIA request. Unsurprisingly, the FAR emphasizes the prohibition on disclosure of proposals, because that's of particular relevance to contractors and government employees who are involved in contracting. And the FAR specifically cautions contracting officers that some FOIA requests may request records that are exempt from disclosure under FOIA, and give some of the examples that I had mentioned that are often applicable to contractor-related documents. If we can go to the next slide, please. All right, now transitioning back to the Privacy Act and specifically the DoD Privacy Program. So the DoD office that is in charge of implementing the privacy program is called the Defense Privacy, Civil Liberties, and Transparency Division. And that office gives advice, monitoring, and reporting and training. There are also, for many of these programs, including both the Privacy Act program and the FOIA program, there are regular reports that provide interesting information and data that give you a little window into those programs. So the Privacy and Civil Liberties Officer reports are issued semi-annually, and they include, among other things, information on privacy breaches and information about privacy complaints. So in the second half of fiscal year 2020, there were 720 privacy breach reviews, and then 12 privacy complaints. And that report also includes samples of some of the complaints that they received in that period. So just to give you a little flavor, so the right side of the slide shows, there was a complaint about an individual that mishandled an SF3107 that belonged to somebody else, and it includes the findings and that the complaint was substantiated, and then the additional actions, inquiry, and then referral for disciplinary action. And then the other example, a complainant claiming that an individual accessed their official personnel file without authorization, and talks about the agency's response there as well. So they provide samples, again, of these complaints in each of these semi-annual reports. If we can go to the next slide. So I mentioned earlier that one of the things that the Privacy Act does is provide for civil remedies if the government violates the Privacy Act. And I mentioned that $1,000 minimum civil penalty per unauthorized disclosure. And so it will come as no surprise that there are lawsuits trying to take advantage of that minimum civil penalty. And the more records are disclosed, the bigger the dollar amount. So, for example, in 2011, there was a DoD security breach where computer tapes were left in a contractor's employee's car and were stolen. And those tapes included medical data for 4.9 million TRICARE participants. And there was a class action lawsuit then for $4.9 billion, of course, based on that $1,000 minimum civil penalty against DoD and the contractor. The judge dismissed the claims, though, because the plaintiffs couldn't show that their data was actually accessed or abused to establish injury in fact. That's a common issue that comes up in big data breach lawsuits. It's usually not enough to show that your information was stolen and could conceivably be misused for purposes of identity theft in the future. Often there has to be more than that. So another high-profile case was involved 2013 and 2014 data breaches involving the VA, and there were two separate data breaches, one of an unencrypted laptop with PII stolen from a VA medical center, and then there were also pathology reports that were stolen. And there again, this was the Fourth Circuit held that the plaintiffs hadn't shown that their information was accessed or abused, and that there wasn't enough there to demonstrate standing. There wasn't even evidence of an intent to steal private information. However, there was a more recent case out of the DC Circuit in 2019 that related to a breach you may have heard of, the famous and famously terrible 2014 OPM hack. And the DC Circuit there found that there was injury in fact based on the risk of future identity theft. The circumstances there were a little bit different. In the other two cases, it wasn't clear that the PII was stolen with an intent to misuse it. In the TRICARE case, for example, whoever stole the backup tapes also took a GPS and so forth. So there were indications that they were just a regular car thief that happened upon all these medical records. So whereas the OPM breach, there were indications, although there were no formal accusations, that it was intentionally perpetrated by a foreign country. So that may have, made a difference in how the court viewed the issues. And there were also a number of plaintiffs who experienced actual identity theft issues later. So 7 of the plaintiffs had false tax returns filed using their information, and there were a number of other issues. Someone had an account fraudulently opened in their name. So these are lawsuits that are likely to only become more common. Of course, it seems like there's a breach, some sort of data breach in the news every week these days. So there will be more of these lawsuits, and of course there are state statutes in addition to the Privacy Act. But that's one angle on the DoD privacy program. There could, in theory, be real money involved with violations of the Privacy Act for the agency. Again, the civil penalties aren't actually applicable to contractors that are operating systems of records on the agency's behalf, but it's a big deal for the agency. And of course, there can be contractual consequences for contractors if they're the ones that actually mishandle the PII. If we can go to the next slide. So DoD Instruction 5400.11 addresses the DoD Privacy and Civil Liberties Program. It starts with the policy that components must maintain privacy and civil liberties programs, and then it talks about some of the ways that the components must comply with the Privacy Act, setting forth rules for creating, collecting, and using PII, restrictions on disclosure, maintaining records, security and privacy controls, and fielding complaints, and prohibiting retaliation. We can go to the next slide, please. So the instruction also talks about the different DoD officials that have important responsibilities under the Privacy Act, the different roles. So the DoD Chief Management Officer acts as the DoD Privacy and Civil Liberties Officer, or PCLO, and the Director of the Directorate for Oversight and Compliance also has an important role as the Chief of the DPCLTD. And then also mentions roles for the General Counsel and the DoD CIO and the IG. The instruction also talks about the responsibilities of OSD and the DoD component heads for maintaining their own programs, and it talks about some of their respective responsibilities under the Act. And it also mentions the Defense Data Integrity Board and something called matching programs. So one of the special activities that's governed by the Privacy Act is computer matching, which is automated computerized comparisons of systems of records. And it's typically used for federal benefit programs, so verifying eligibility and collecting debts and that sort of thing, and for purposes of federal personnel or payroll systems. And so the Defense Data Integrity Board has responsibility for those particular rules. We can go to the next slide, please. So the instruction also sets forth rules of conduct and provides information about fair information practice principles. So the rules of conduct apply to DoD personnel involved in systems of records, and of course it also extends to contractors to the extent that contractors have contracts to operate systems of records. And then the fair information practice principles track a lot of the principles that are right out of the Privacy Act. So corresponding to the rules and rights under the Privacy Act, individual rights to access and amend records if they're incorrect, government rules regarding accountability for records, restrictions on what's collected, agency responsibility to ensure quality and integrity of information about individuals, and then, among other things, security, so administrative, technical, and physical safeguards that the agency is required to have for PII. Next slide. Now, if we move on to the self-described regulation 5400.11-R, which goes into greater detail on DoD's privacy program, it first addresses applicability, governing systems of records, and it provides a definition of systems of records. Notably, the foreword to 5400.11-R specifically calls out applicability to contractors. So it says the provisions of this regulation shall be applicable by contract or other legally binding action to U.S. government contractors whenever a DoD contract requires performance of any activities associated with maintaining a system of records. And then it specifically calls out the fact that contractors and their employees are considered employees of the contracting DoD component for purposes of criminal penalties under the Act. So kind of fair notice that there can be severe consequences for mishandling PII. Next slide, please. So continuing through 5400.11-R, and again, kind of tracking and elaborating on different provisions of the Privacy Act. It talks about collecting personal information with particular rules for Social Security numbers, and specifying Privacy Act statements and forms. Then providing details on the process for individuals requesting access to their records, rules for disclosure of PII to other agencies and third parties, including to other DoD components, and then certain exemptions from the coverage of the Privacy Act, including sort of predictable exemptions for classified material in law enforcement. We can go to the next slide. Continuing through the issuance, there's information on publication and training requirements. So one requirement of the Privacy Act that I haven't touched on yet is agencies are required to publish in the Federal Register what are called System of Records notices. And those notices describe the name and location of systems and records, and then are required to include other information such as categories of individuals that the records in the system includes, categories of records that are maintained, routine uses, including who can access the records and what they use the records for. And then they also are required to publish agency policies and practices relating to the records, among other things. So that's what the publication requirements go into. And of course, training is also required, tracking what is required under the FAR, but extending to both government and contractor personnel. And then some oversight provisions. The issuance calls for reports and inspections to support the Privacy Act compliance and reporting of any findings. It provides policies and procedures for violations, and then has more on computer matching programs, which I mentioned a minute ago. You can go to the next slide. All right, so if we can transition, switch gears now back to DoD's FOIA program. That would be helpful first to kind of provide a little bit of context in how DoD fits into the government-wide FOIA program. So as I mentioned before, DoD is, I'm sure you know, accounts for maybe 60+% of federal procurement dollars. The agency receives a comparatively small proportion of DoD FOIA requests, as you can see from the chart here, about 7%. So in fiscal year 2020, that translated to 54,000 FOIA requests, and they processed 50,000, so they have a little bit of a backlog, and that's common across the federal government. a lot of agencies have trouble keeping up with FOIA requests because there are so many of them. Really, they do their best to kind of manage that backlog. And so the federal government overall received north of 790,000 FOIA requests in fiscal year 2020, and that's not atypical. In a lot of years, it's around 800,000, sometimes more. And just for a little bit more context, there was a study in 2017 that looked at who was submitting FOIA requests, and media organizations kind of have a reputation for submitting FOIA requests. You know, reporters will use FOIA to find out about the federal government. But the 2017 study found that businesses used FOIA frequently, as did individuals and law firms, among others. So of course, government contractors are not it's not unheard of for government contractors to use FOIA. In fact, it's fairly common, and government contractors will use FOIA to learn about government programs often, or sometimes about their competitors. And sometimes FOIA is even used in litigation against the federal government. So in claims litigation, for example, to supplement discovery in claims litigation. You can go to the next slide. So to provide a little bit more about the FOIA process, including the appeals process, and then kind of how what the overall government-wide results are. The left side here traces, the FOIA process from the submission of a request, the government review of that request, which includes intake and notice, search for records, processing records, and then approving release and providing response. Of course, they may not approve the release. They may assert an exemption when they respond to the requester. And then there's an administrative appeals process. This notes there's a 20-day time frame for the agency to respond to the requester, and that's a statutory time frame. In exceptional circumstances, the agency can go over that. And then there's also an administrative appeals process with the agency, and agency regulations specify the time to file that, and DoD specifies a 90-day time frame in its regulations. The DoD FOIA regulations are at 32 CFR section 286, and then there's after the requester files an administrative appeal, if they don't like the agency's FOIA response, the agency has 20 days to respond. And then if the administrative appeal also doesn't turn out the way that the requester wanted it to, there's the possibility of judicial review, but you have to generally have to go through the administrative appeals process first. You can go to the next slide. Oh, I was going to mention one other thing on that last slide. I didn't speak to the disposition of all processed FOIA requests. So the DOJ Office of Information Policy puts out annual FOIA reports, and DOJ OIP is in charge of the government-wide information policy, and it has all kinds of guidance documents relating to FOIA. So it's a great resource for all things Freedom of Information Act. But this little chart is from their annual FOIA report for fiscal year 2020, and it shows, in 21% of cases, government-wide, they fully granted the FOIA request. Another 40% had partial grants, and then there are various other reasons for not providing the records that are requested. So ranging from there weren't any, no record, 16%, or improper, and then there are other less common reasons for not providing the records that are requested. We can go on. Next slide. All right, so DoD Directive 5400.7 again, starting with the higher level issuance, talks about the DoD FOIA program's policy and reiterates the statutory policy adopting a presumption in favor of disclosure and also a policy of responding promptly to FOIA requests and in a spirit of cooperation. And then it references the DoD FOIA regulation at 32 CFR Part 286. Then it, as with the Privacy Act issuances, the DoD directive for FOIA lays out the responsibilities of different officials. If we can go to the next slide, please. So now the manual again goes into kind of greater detail on the processes and procedures associated with implementing DoD's FOIA program. It restates the public right to access records, again citing the DoD FOIA regulation. The manual also provides a link to DoD's FOIA handbook, which is intended as a public reference for people that want to submit FOIA requests to DoD. So that provides useful information. The manual also notes that DoD's FOIA program, as I mentioned earlier, is largely decentralized, and so most DoD components have separate FOIA offices, and that's an important thing to be aware of, because if if you're submitting a FOIA request, you want to direct your request to the right office, the right FOIA office, in order to improve your outcomes and get a more timely response to the request. You can go to the next slide. Then tracking through the manual, it talks about DoD FOIA libraries, which establish DoD component records available online for public access. I mentioned that before. It's one of the other FOIA mechanisms besides FOIA requests, which include, frequently requested records, and convenient that those are available on the internet. The manual also talks about the FOIA exemptions. I mentioned earlier the FOIA annual reports. So DoD's annual FOIA reports describe the different exemptions and list the number of times that different exemptions were asserted. It's kind of interesting information to look at. It also lists the statutes. I mentioned Exemption 3, which prohibits disclosure of information as provided for in other statutes. So the DoD FOIA reports list the different statutes that DoD has used to justify not disclosing certain information under Exemption 3. The manual also talks about the FOIA request processing process and the procedures for processing FOIA requests, and it mentions the 20 working day statutory time limit, and includes procedures for initial determinations and dealing with exemptions and other denials of requests. And then it also specifies education and training for DoD personnel involved in FOIA requests and for DoD attorneys. Go to the next slide. So among the different FOIA exemptions, as set forth in the manual addresses Exemption 4. And I mentioned before that the DFARS isn't completely up to date, and sometimes things happen that make the DFARS or the DoD issuances outdated, and they're not always timely updated. So this is another example of that and something to be aware of. So the treatment of Exemption 4, which again applies to trade secrets and commercial or financial, proprietary company information. It tracks the old legal standard for Exemption 4. So it provides that where proprietary company information is voluntarily submitted, the standard is that it not be customarily disclosed to the public by the submitter. And then there's a separate standard for information that is not voluntarily submitted. And it's a two-part standard. If the information is not supposed to be disclosed if it could impair the government's ability to obtain the information in the future, or the test that is most commonly known is what's referred to as the substantial competitive harm test. Cause substantial harm to the competitive position of the person providing the information. So traditionally, Exemption 4 reverse FOIA litigation, if a contractor's information is being requested under FOIA and the contractor wants to bar the release of its proprietary information under Exemption 4, that requires a showing of substantial harm to their competitive position. So the kind of concrete ways that the release of the specific information would make it harder for them to compete in the future. But if we can go to the next slide, I guess it's on the slide after this. I'll talk about it in a minute. That's the old test, and it's been overruled by the Supreme Court. So the manual provides a little bit more on Exemption 4, and it references the DoD FOIA regulation. It also talks about DoD's process if there is confidential commercial information that's requested that may be covered under Exemption 4. And the triggers for that are if information has been designated in good faith as being covered under Exemption 4. So what that's talking about is if a contractor marked the information as being proprietary, then if DoD receives a FOIA request for that document that has a marking, that's an automatic trigger for the DoD component to notify the contractor. And they refer to this in the FOIA context as a pre-disclosure notification. And the DoD component is also supposed to use their own judgment if they think that requested information might be covered under Exemption 4. But certainly the marking is the best way to make sure that there's a pre-disclosure notification. And there's a reference here. I included a reference to Executive Order 12600, which was the original requirement for pre-disclosure notifications that's now mirrored in the DoD manual. You go to the next slide. So I mentioned Supreme Court changed the standard for Exemption 4. The old test was referred to as the National Parks test, and that is the test that is now included in the DoD manual still, which says that information is only confidential and protected under Exemption 4 if it'll impair the government's ability to obtain the information or cause substantial competitive harm. And that test applies where information is not voluntarily submitted. And then there was a separate test for voluntary submissions. And that's a less restrictive test. It said that information was confidential if it was of a kind customarily not released to the public. So contractors or other companies that provided information to the government only had to show that they treated the information as secret or proprietary and didn't widely release it. The case that changed all of this is called Food Marketing v. Argus Leader. If we can go to the next slide. And that instituted a new test, although the court didn't entirely nail down what the test required. The court scrapped the old National Parks test and said it was essentially based on an outdated approach to statutory interpretation. And the new test involves one mandatory prong and then one other prong that might also apply. So for information to be exempt under Exemption 4 as confidential, the information must be customarily kept private or at least closely held by the person imparting it. And that, of course, tracks the old test for voluntarily submitted information under critical mass. And that was perceived at the time as being a lower standard, although the application of the new food marketing v. Argus Leader test is still kind of playing out in the courts. The court did leave open the possibility that parties would also need to show that the government had provided some assurance that the information that they provided would be kept secret. And the court raised that issue, but it wasn't at issue on the facts in front of the court at the time. So that was kind of left open to subsequent courts to interpret as potentially being an additional prong, just on the theory that if contractors or companies disclose information to the government without being told that it'll be kept secret, that could be seen as waiving any right to object to its disclosure at a later time. And that kind of tracks a little bit with trade secret law, that you would want some assurances that the information will be kept secret to be able to enforce later the requirement for secrecy. So we can go to the next slide. Oh, maybe one final point I think on the post-food marketing v. Argus Leader litigation. I mentioned that the courts are still kind of deciding, and there are different approaches in different circuits as to how to apply the food marketing v. Argus Leader test. The courts have not uniformly approached the assurances of privacy and whether that's actually required. Another wrinkle, though, that's come into play is that there was a statute enacted that didn't apply during the time period of the facts in food marketing v. Argus Leader, called the FOIA Improvement Act of 2016. And that act provided that an agency can only apply a FOIA exemption when the agency reasonably foresees that disclosure would harm an interest protected by the exemption. So some of the courts that have considered Exemption 4 after food marketing v. Argus Leader have looked at that FOIA Improvement Act language and have found that it imposes, again, a requirement to show some harm from release of Exemption 4 information. So it'll be interesting to see as that continues to develop whether there's some level of consensus across circuits as to what the new Exemption 4 standard is. We can go to the last slide. Oh, you're already there. Just some final takeaways. So again, we talked about the Privacy Act, and the associated regulations and policies of the Privacy Act are primarily intended to promote privacy and individual rights. This mostly comes into play in the government procurement context when contractors are managing systems of records that include PII. And so if you're on the contractor side, you should be looking for the FAR clauses associated with the Privacy Act and references in the scope of work to know that the Privacy Act applies and that the agency rules associated with the Privacy Act will apply. And both contractor and government employees have to be really careful when handling PII, or there can be serious civil or criminal penalties for mishandling that information. As far as FOIA, again, the kind of high-level policy objectives are government transparency and accountability. And when it comes to contractors, as I mentioned, contractors frequently use FOIA as a competitive tool to learn about the government and government programs, or to learn about other contractors. And of course, contractors also have to disclose proprietary information to the government in proposals and in performance of contracts, and need to take precautions to make sure that their information isn't disclosed under FOIA. And government employees then have a responsibility to be aware of the fact that contractor information may be exempt from FOIA, including exemption under Exemption 4. and of course the FAR spells that out, and it's mirrored in the DFARS FOIA policies. And the DoD FOIA issuances and regulations are important because they establish key timeframes and describe the agency's process. So it's a valuable resource for any party, whether you're on the requester end or if it's your information that's being requested. The DoD issuances provide a useful resource for the agency's process. And I mentioned on the requester side, the organizational information, different FOIA offices for different components is important for having a good outcome for a FOIA request and a timely response. And then the DoD regulations provide specific timeframes applicable to the administrative review process. So that concludes my presentation. I understand that we will not be taking questions, but at least here on this webinar. But if you have questions, I would welcome an email. Feel free to get in touch. My contact information is on the final slide. And I appreciate you taking the time to spend your lunch hour with me.
Thank you, Daniel, for your presentation and spending your time with us. And thanks to everyone who joined us. The recording will be on our website and YouTube channel within the next 24 hours. Please join us next week as we cover more parts of the DFARS.